Tonight, joining us here in studio, criminal defense attorney Ashley McMahan, trial attorney and law professor at Emory, Randy Kessler, and criminal defense attorney Tiffany Porter with us as well. Great to have you all here. Eyewitness testimony. Criminal defense attorneys are always jumping up and down. There's no eyewitness, there's no eyewitness. We got like half a dozen here. And this guy saw everything, Tiffany, everything.
Well, it's going to be up to the defense to really cut through his testimony to find holes and to make sure that everything that he said that he saw is accurate. We usually try to find inaccuracies in testimony and try to trip them up to just see if they're going to say something contradictory to what they testified to. Now,
he says he didn't see him break, right? You got these experts today, it was a bunch of gibberish, right? But if you're looking, if someone breaks, what do you see? Brake lights. Didn't see any brake lights.
Well, here's my problem with it, Vinny. He said a deliberate driven action. That is so bad for the defense. If I'm a defense attorney in this case, I'm jumping up and down. That is speculation. This is a case all about intent, okay? Whether or not this defendant intended to hit this victim with his car. I mean, this is the nail in the coffin for the prosecution. You know, him saying, look, no, he did it deliberately. I didn't see him slow down. He had a driven action. You know, if I'm the defense attorney, I don't even care if the objections are getting sustained. I am jumping up and down, waving my arms, trying to distract the jury during this testimony because it's so bad for this case.
Yeah. So I think this witness means what he says. He really feels like this guy did it intentionally. He was a friend of his. He knew who he was. But you use that as a defense lawyer. You say, listen, you want this guy to pay, don't you? You want him to be punished for what he did because he killed your friend, right? And so therefore you're filling in the blanks. You're saying he didn't put his feet on the brakes. You didn't see his feet touch the brakes. You're saying he meant to kill him. You don't know what he meant, do you? No, but he must have meant to kill him because we all want somebody to pay when something happens to anybody, much less a friend. You got to use that bias and say, you're exaggerating the facts. You should just say what you saw. Don't go beyond that. That's all the defense can do.
Yeah, but they've got to do that maybe in argument, maybe, not so much in cross-examination.
Or get them defensive a little bit. Let them fight a little bit. Let them say, no, I'm going to tell you. I mean, if they get them to say, you want this guy to pay, you know.
Julie, Janae, tell me a little bit more about this witness, because just the way he testified, from my perspective, was just so credible, and you could tell he had this look on his face. He's a man who's dedicated his life to keeping kids safe, and sees this guy screaming past his lights and kill a man. And he did have that look in his face like, you know, I know what I saw. This is serious. I understand what happened here, and I'm telling the truth.
Right, he did have that look in his face the entire time, and I think that's what really captured this jury's attention because he was so passionate about what he was saying. You know, he even said without any reservation that he knew exactly what the defendant looked like. Now, the defendant was in a car, he was in a bus, the defendant was wearing a cap and, you know, was speeding by him, but he said, I would notice him again if I saw him, and he pointed him out in court today. So, very emphatic testimony from Jeremy Hicks, and you just feel, just like you did with James Savelle, that they really care about their job, they care about the kids that they're protecting, and as soon as they saw this happen, they leap into action.
All right. Now, today inside the courtroom, before this witness testified, Mr. Hicks, the bus driver, I mean, it was confusing. The jury was distracted from it. All the state's expert trying to explain about brakes, speed, this, that, and to me, it turned into mush.
Mistake. It's a mistake. Why do you bring an expert witness unless he's going to say there were no brakes? If it's confusing, you don't need him, right? I mean, if you got this guy that's so adamant, I didn't see brake lights, I didn't see, you know, they gave the defense an opening.
Well, the defense expert obviously is going to talk about it as well, and that's who their key witness is going to be in their case. But here's my question. Juries, okay? There's a juror. This jury has no notepads. They're not taking any notes. They're just sitting there watching the trial like all of you at home. Are they going to give more weight to Jeremy Hicks or the paid expert from the defense? Because we know what that paid expert's going to say. And the one for the state is paid also, but Jeremy Hicks just gets paid to drive this bus. He doesn't get paid to testify. who are they going to give more, which is going to have more impact with the jury?
I absolutely think that this is a very good emotional case for the prosecution. The jury is definitely going to listen to lay witnesses and to everybody that knew this victim. I mean, this is a case where you've got to, sometimes, you know, as defense attorneys, we get cases where the victims are not such, I want to use the phrase, savory characters, all right? Nobody comes out smelling like a rose in some of these trials. That is not the case here. You've got a very sympathetic victim. You've got a neighborhood man, a family man that everybody knew that was arguably going out of his way to protect children when he was brutally killed. You know, you've got, if you're the prosecution, you've got to take advantage of the fact that this is an emotional case and that jurors are going to connect with that. Don't muddle things by throwing in an expert where you don't need one. I agree with Randy.
Not only that, you got a sympathetic victim, but you got a sympathetic witness. I mean, the witness is a school bus driver that his job is to protect children. So, you know, you got all the sympathy you could ever hope for in a trial.
All right, we've got a 13th juror question tonight, too. And the jury, before all the testimony, visited the scene. They drove over the speed bump. They went past where Mr. Maynard was killed. Does the jury's visit to the scene help the prosecution or defense? Go to our Facebook pages, Vinnie Politan, CourtTV, or just CourtTV, straight up. Strong finish by the prosecution today into tonight. Jeremy Hicks, bus driver number 2, testified, and through his testimony, the prosecution was able to put in a second videotape from this second bus. It is riveting, it is compelling. Let's take a look.
How'd that happen? Was he joking or is he serious?
Like you can't see anything, see there. That's kind of scary if that's true.
Very serious. Very. How y'all doing?
Then that could be something scary.
Could be very serious.
Have you any cold dark coats in your house? You didn't give me anything. It's a shame. You didn't bring me pizza. I only had one slice of pizza. That's what I had to do. I had to go down and order it. You had no idea what I was going to give you for that.
Hey! Idiot!
What was that?
Oh my God, he just hit that man! He just hit that man that was in the four-wheeler, Terry.
What do you want to do? Call 911?
Yes, call 911 right now.
What's this friend called? Friends like a
Sounds
snake?
like the stage by the clubhouse. Tell him to come by the clubhouse. No, the man was on the ground. He was on-
What?
The man hit and ran. He hit and ran.
So there you see Jeremy Hicks jump off the bus to see if he can help, and you saw there's a second individual that was on the bus as well, getting off at the end. But the significance of this is eyewitness testimony. Now, most of the other witnesses who testified, I think, had a different perspective of everything. He is watching him pass. That's how he gets his attention. And he sees him coming fast. He's honking the horn for him to slow down. He's got the lights going. as he's letting off a child. And then as he passes, he says, "Slow down, you idiot," or just "you idiot." And at that point, you could see that he's watching everything in his rearview mirror as the student is getting off the bus. And then at that point, he sees the impact and jumps into action to try to help John Maynard. And in the beginning of the ride, you saw that he kind of leans and waves and is waving. And in his testimony, he said he knew the man's name was John, didn't really know him, but knew him and recognized him from the neighborhood. But that student in the bus clearly knew Mr. Maynard and knew him as John. I mean, it tells you a lot about the victim in this case as well. Bring back in my think tank. First reaction to the video. Oh,
I have goosebumps. I mean, just watching it, what a fantastic piece of evidence for the prosecution to use in this case. I mean, we know it's an emotional case, but now we get to actually watch. You know, you have eyewitness testimony, people's memories fade, they're not as reliable on the stand. And just like Randy was saying earlier, it gives defense attorneys the ability on cross-examination to say, look, you're emotional now. This is all in retrospect. Your testimony may be tainted because of it. That video is not tainted, though. That video is unbiased.
Reaction video is unbelievable. Now, we know the car hit him. If we had to use I wish we had the video of the car hitting the gentleman, but the car hit him. Sometimes reaction video is better than the actual video. Just like when you see, you get a shout out from a star. Well, how does that affect the recipient? You see the recipient's reaction. That's what goes viral. What goes viral is, how do these people react to what they just saw? That's the human nature. How would I react if I saw it? I'd be mad too. I'd be upset. And I'm on the jury. The reaction video is important.
Well, I'm going to take a different approach. I think that this video helps the defense.
How?
It helps because, yes, we know that he witnessed the actual, the impact. However, this case, again, is about intent, right? So just from what he saw, and if I'm looking from his vantage point, he could not tell what else was going on. So for me, I would argue you don't know whether this was an accident or if this was intentionally done. Based on what you saw, it happened so fast. I think that this is a good video to show that although he saw it, he can't interpret exactly what was going on with the defendant at that time. So I think it helps the defense.
And it really goes to the ultimate issue, what you're talking about, which is what's going on in his mind. Why does the car veer off the road? Does it veer off the road because of the speed bump? Does it veer off the road because he's intentionally going after this man in a fit of road rage? The one thing, and this is an important fact from yesterday that came out from a witness who was sympathetic to the defendant but was called by the state, who it seemed the whole issue in the beginning of this was a beer bottle or beer can. That the only thing this defendant talked about after killing Mr. Maynard was that he threw a beer can at my car. That's the first thing he says to someone that he speaks to. So let's take that fact and weave it into this video and what this defendant saw. What comes out at the end?
Well, no comprehension of what he just did or what he just, how he just hurt this guy. But before that, Tiffany's right. The bottom line is, when you see the witness on the witness stand, you almost think he was looking right at it and it happened right in front of him. That's sort of the mental image you get from the witness stand. When you see the video, oh, he saw it, saw him go, he saw the mirror. It's a much lesser direct impact. But to answer your question, yeah, the beer can, it sounds like, oh, he's trying to make up an excuse for why he did what he did. That's all he's worried about. It's not my fault, it's not my fault, it's not my fault. He threw a beer can at me. The jerk, blaming the victim, again.
But the problem is, it sounds like he's trying to come up with an excuse very quickly after this happened and not even acknowledging, hey, I hit that guy, something like that would maybe humanize the defendant and seem like a more normal reaction from a person, I think works against the defense. It does make it sound like he's trying to come up with an excuse immediately.
Yeah, but it's a different excuse than the lawyers and the expert for the defense are coming up with, which is it's all about the speed bump. Yet, this defendant does not mention the speed bump at the time or the day of the impact. Our 13th juror question is about something else that happened today. It was a jury view. Does the jury's visit to the scene help the prosecution or the defense? Go to our Facebook page or Vinnie Politan Court TV on Facebook. Please leave a comment. Comment on the other comments. Let's get the conversation going.
Vandergriff. Vandergriff is on trial for the hit-and-run killing of John Maynard, a 38-year-old father who, according to authorities and witnesses, tried to stop a collision between Vandergriff's speeding silver Chevy Cavalier.
This defendant intentionally ran over John Maynard, that he did it with malice, with premeditation and deliberation, in less than 10 seconds and 320 feet.
Basically, the school bus was doing a U-turn when Vandergriff allegedly was coming down this street at a high rate of speed. So when he did that, this Good Samaritan jumped in front of into the road area and said, basically, slow down. Well, authorities say Vandergriff then accelerated and turned his Chevy Cavalier towards Maynard, killing him with the impact.
Welcome back. Big day inside the courtroom in West Virginia. They went late tonight, and it looks like prosecutors have wrapped up their evidence, but they won't officially do it until tomorrow morning. And obviously, the prosecutor could have a change of heart and could call another witness. Now, one of the things about this case, a lot of different eyewitnesses. We've seen evidence photos. We've seen these videos from inside the bus. But sometimes you got to pull back to see the big picture, to try to put it all together and understand what this scene was like. Unlike many cases, this one so much is about what happened and where it happened. And towards that end, today the jury actually went on a view. They went to the neighborhood, they drove down the street, they went over the speed bump. So what I want to do for you tonight is take you on a view of the scene and take you back so you get a much better picture of what the scene was like and try to put together what all this testimony really means.
May 9th, 2008, a quiet afternoon in the Ranch Lakes Estates subdivision in Scott Depot, West Virginia. Two school buses are dropping kids off after school. A surveillance camera from one of the buses shows a Chevy Cavalier pass by right before the driver, Morgan Vandergriff, struck and killed 38-year-old John Maynard.
Hey, did he hear him? Yeah. Went off the road there, Eddie. My God, is he hurt bad? Yes, he did.
That bus is in a gravel pull-off, making a U-turn, while another bus is on the street waiting to make the same U-turn. Vandergriff is speeding down the road, a 20-mile-per-hour zone. Maynard is in his neighbor's driveway. Vandergriff drives over a speed bump and strikes Maynard with his car. There are two versions of how that happened. Some witnesses say Maynard approached Vandergriff's car as he sped toward him, waving his hands to slow him down.
Morgan got out, and I was just like, "Are you okay? You know, what happened? What's going on?" And the first thing that he said was, he hit me with a beer can.
Others say Vandergriff swerved into Maynard on purpose.
He got about 2-3 feet from my driveway. He swerved to the right, hit John, knocked him up in the air. He turned a somersault.
A police sketch shows skid marks from Vandergriff's car were found leading into the driveway. Maynard's body landed in a nearby ditch. Vandergriff's windshield is left shattered from the impact. But was this a tragic accident, or was this murder?
And don't forget what the charge is here. First-degree murder. Premeditated murder. Life in prison if he's convicted. That's what is at stake here. Now, prosecutors are also going to try to get this jury to be able to consider a lesser included if they don't believe there's enough for premeditated murder. And listening to this case and what the defense is doing, it's a very unusual defense. You know, usually the defense is, no, we didn't do it, and you try to distance yourself as much as possible from any of this wrong conduct. But here, the defense is actually prosecuting their own client for a lesser included charge here, admitting that he's driving so recklessly, because the defense to premeditated murder for this team is prosecuting him for being extremely reckless in the way he's speeding through this neighborhood and driving at a fast rate of speed over the speed bump, which throws him out of control. So it's an unusual case in the way the defense is approaching it, but that's the way they're conceding that this guy should not have been doing what he was doing, but they will not concede that he intentionally, with premeditation, ran over and killed John Maynard. Let me bring back in my think tank tonight, Ashley McMahan, Randy Kessler, and Tiffany Porter. First-degree murder, Tiffany.
Nope. I think that it's going to be really hard to prove first-degree murder. I mean, you have to look at the intent and who I think the prosecution will have to display why he did it and come up with the motive. If you don't have that, besides just saying that he was speeding, then he's just negligent and reckless. But the intent, I think it's going to be really hard to prove in this case.
I agree. I mean, you can form the intent instantaneously. You can say he looked at him, he got mad at him, he thought the guy was giving him the finger. Who knows what the reason was? But I haven't heard anything like that. I haven't heard that he knew him beforehand or he'd, cheated with his wife or his girlfriend. I mean,
there's no connection between the two men.
Right. So
no connection.
So why would he premeditatedly kill this person? I mean, did he say in his mind, I'm going to go out today and kill somebody? That might have done it. But until we hear something like that, I think the state's better off, trying to get him for something lesser than that, because if it's all or nothing, he might walk.
They're going to include, I think, lesser included charges on this case, and
defense doesn't want him.
Right. Well, of course.
The judge will allow. Of course, because all or nothing. Would you let this guy walk out of the courtroom?
I don't know that they get to premeditated murder. I don't know that the prosecution gets it in this. And just like Randy said, you can form intent instantaneously, but there hasn't really been any, other than the last witness today, who basically testified to speculation about what his intent was, because you can't really know what's going on in the defendant's mind, if you're just a bystander. I don't know that they get there.
I don't know that I like to do this, but I'm agreeing with you, Vinny. The truth of the matter is, if it's all or nothing, and you're on the jury and you say, well, either we got to convict him of premeditated murder or he's acquitted, you might be on the defense side, you might say, hey, that scares me because he's going to get premeditated murder. The jury might just do that, but
does somebody who is acting the way he is get I'm not talking about reasonable doubt here. I'm not talking about a legal standard. I'm talking about like a common sense, everyday benefit of the doubt. Okay. I think somebody's going 40, 50 miles an hour past two school buses. One's got the lights flashing through this neighborhood where the roads are like this. Two school buses, there's probably kids everywhere.
When you have a little kid saying, hi, John, right before he's killed, I mean, whew.
And by the way, after impact, he disappears. I mean, most of the eyewitnesses there thought that he was gone. He had gone to the next house to go fix a lawnmower.
That part is bizarre.
Well, that's his reason for coming to the neighborhood. He's coming to fix his friend's ex-girlfriend's lawnmower. She's mowing one of the neighbor's lawns. And that's why he's driving 50 miles an hour past a school bus in a residential street in a neighborhood where it's like just about wide enough for one car at a time to go.
Who's going to say anything nice about this guy? I mean, there's no character witnesses unless he testifies on his own behalf and he's really likable. I mean, that's the hard part. Everyone's saying bad stuff about him. This isn't, like you said, Ashley, it's an emotional case, and the emotion is all on one side.
Well, what about the jury instructions, right? The jury is going to get a set of instructions, and they're going to go through the law and what it is and what premeditated murder means. And I don't believe they get to that, regardless of emotions. If you have jurors that are actually going to try to follow the law and follow what it says and what he's facing, do we really get to first-degree murder? I don't think we do.
And consistently from polling juries, I think we'd all agree on this. Most jurors, regardless of how much they know about the law, and usually it's not very much, try and do the right thing. Try and follow what the charges are that they're given by the judge. They attempt to get there. Sometimes they do come to a conclusion and then sort of try and backdoor their reasoning into it. But I think that's the exception, not the rule. So,
But they go with, it's about justice, right? They want to do justice. And whether somebody proves it or not, if they feel like justice is that this guy should go to jail, that's their mindset. How can we make the law apply so that this guy goes to jail? That could happen too.
But they shouldn't.
No,
So that's the defense job, is to point that out, that you need to follow this to the letter of the law. I want you to, when you go back there and deliberate, to understand what the law is and understand what happened
100%.
in this case. This was an accident, and this was not intentional. And if you, without the intent, you have to acquit.
Or it was reckless, or it was something less than
Let
premeditated.
me tell you what I would do as prosecutor here. I would take the defendant's own words and whoosh, right back at him. What's the first thing he said after he killed Mr. Maynard? He threw a can of beer at me. There's your moment. Road rage. Every juror knows, right? Everyone knows when we get behind the wheel of a car, we become a different person. Even Randy, nicest guy in the world, has a little mean streak when you get behind the wheel, right? People are doing things, something happens to us. So it doesn't take that much. And if you're already in some crazed state of going 50 miles an hour past the 2 school buses with the lights flashing on one of them, would it take much more than your perception that someone's throwing a can of beer at you to maybe act out? And there's my premeditated. That's what I would argue. The thing is, though, in this case, I think the prosecution is trying to distance themselves from the beer can. But I'm going to say he didn't actually throw the beer can, but he thought that the beer can was thrown at him, and that's why he did it.
That's enough to run over someone?
But
When you're in a crazed state, when you're going 50 miles an hour through a neighborhood, this person is not normal.
But Vinnie, you're right.
There's obviously something wrong with them.
You have to explain why would he do it. I mean, Tiffany, you were saying at the break, why would a person do that? Why would somebody actually drive?
That's what the defense attorney talked about in his opening statement. Exactly what you're saying. Why? I'm answering your question.
They haven't answered it. Throwing a beer can.
Well, Vinnie, this is a problem. You're not on the prosecution's dream team.
Well, I think she's going to go there.
After she watches you tonight.
No, but it's one of those facts. You have to get into his mind. All right, so let's use his words to get into his mind. Now, his perception of what was happening wasn't true. The guy's waving his hands. Maybe he thinks he's throwing something at him, so that's why he goes after him.
That's what Tiffany said, motive. How's the prosecution going to prove motive? That might be how.
That might be it. All right, folks, we got a 13th juror question for you. It's about what the jury did earlier today. Does the jury's visit to the scene help the prosecution or defense in this case? We took you on a tour. They went on a tour. Who's better today because of that? Prosecutors or defense? CourtTV's Facebook page or Vinnie Politan, CourtTV. All right, the whole day wasn't great for the prosecution today. I will admit that. They put in their accident reconstruction expert, Ronald Thayer, and I sat and I watched, and my head was spinning. I think there was smoke coming out of my ears. I couldn't quite follow everything. It became very confusing, and at times I felt like it was probably a little better for the defense. Well, what I'm going to show you now is the cross-examination of that expert. And remember, this is the expert brought by the state. But the thing is with experts, you don't just make up, you're not supposed to make up an opinion just to appease whoever hired you. You're just supposed to tell the truth. So let's take a look at this testimony and see if it damages the prosecution's own case or not.
All right. Thank you, Your Honor.
Can you cross? Yes, Your Honor. And thank you. My name is Brian Askew. I represent Mr. Vandergriff. I read your report, and I was following along as you were testifying, but it seemed that you did state what you believe to be the speed at impact.
Yes, I did.
And you didn't testify that earlier, but what did you say the speed of the impact was?
I said it was if we determined that deceleration was continuing, it would have been somewhere around 32 to 36 miles per hour.
And I'm publishing State's Exhibit 65, Your Honor.
All right.
On the Elmo, which I promised myself I wouldn't use. Now, can you state that again?
Your Honor, I'll just ask an answer.
I'll allow it. Go ahead.
Apologize, Your Honor. Can you state that again?
If we assume, and again, we don't have enough information to be conclusive, but if we assume that the vehicle is continuing to slow for that last second, it would be my opinion that the speed would have been somewhere around 32 to 36 miles per hour.
Okay. And you were contacted by who to testify?
This car.
Okay. And I read your CV. You've testified in these before, correct?
Yes, sir.
So when you put stuff in a report, I mean, it's really your word.
That's correct.
5 years from now, if another attorney catches on that you're just doing erroneous data or making something up, this could be detrimental to your career.
I suppose so.
So by you saying 32 feet or 32 miles per hour to 36 miles per hour at the time of impact, I mean, that's just not a number you grab from the air. That's something you believe based upon your entire view of the circumstances that this is what it is.
I believe I also stated that it could have remained the same or actually increased in my report.
Correct.
Yes.
But that's a range.
That's correct.
We're not locking you down.
I agree.
And there's also other ways that reconstructionists use to see what's actually happening, correct? Like the difference between the bumper height and the break in the bone.
Again, more information would be needed to form a conclusion there, yes.
Right, but we could add those two together, could we not? That the computer that's independent is saying it's decreasing, and if that is consistent with the lowering, I mean, that together makes it more plausible, correct?
Pedestrian injuries and behavior of pedestrians in crashes is an entirely different area of reconstruction. The only thing that can be determined about a leg break or a fracture of any kind would be a minimum speed. Anything higher than that, there'd be no way of determining that.
But it can show braking. Like, not braking as in the bone, but braking is at what the car is doing.
Possibly.
With this and in your report, we can actually go back from the time of impact of what the data recorder collected, correct?
Correct.
And we can move our way back the road, correct?
Correct.
And that's by, I believe, accident reconstructionist uses feet per second is probably better.
We use velocity and speed and using acceleration rate and then a percent of gravity or acceleration factor to work out a distance, yes.
Okay. So in this instance, you can say that if you, in your report, stated that it was traveling at 32 to 36 miles per hour, you put that down in feet, correct?
I calculated a distance, yes.
And what was that distance?
I'd have to look at my report, sir.
Well, may I approach, Your Honor?
You may.
I believe for the speed slowing from 40 to 32 to 36, a distance of 44 to 63 feet is what I calculated.
From 44 to 63 feet.
That's correct.
Now, from my perspective, this expert totally credible, you know, but it's hard to follow. And one of the big problems in this case, it's a 2003 Chevy Cavalier, and the information he can retrieve from it is not the same as you would with a vehicle that's built after 2012, where the standards became increased, so they would know the exact speed at the time of this impact. But here, this last second, apparently he doesn't know if it's going up or going down. But at some point, he's saying that there's some braking going on here, that it's slowing down.
That's it. I mean, he just bolstered the defense. I mean, if there's a possibility that there's any braking, and apparently what we've learned from the cross-examination of this expert is that he could have been accelerating, he could have been braking. We have no idea. I don't really know what the point of his testimony is, if that's the conclusion that he came to. If I'm the prosecution, I don't know that you call him or you need to. But if he even goes as far to say he might have been braking, that's enough.
That's all you need. I mean, you want to impeach him. You want to make sure he doesn't look so credible. So it's fine to keep him on the witness stand. But I'm thinking I would have asked him one question. Is it possible he pressed the brakes? You get a yes. That's your closing statement. You remember I asked that guy one question. The whole case. Is it possible he pressed the brakes? He said yes. That was their expert. That's my argument.
Right, and it was based on assumptions. He said, if we assume, then, and that's not enough. If, then, assumption, that doesn't equal a conviction. It
wasn't, you know, there was another witness on the stand today, and for a moment, I was almost thinking we were in the middle of my favorite legal movie of all time, My Cousin Vinnie. We're talking about tire tracks and skid marks and everything else, which was the key to that case, may very well be the key to this case. Take a listen to the testimony of Sergeant Chad Ashley from the Sheriff's Office in Putnam County.
And can you tell the jurors what we're looking at here?
A tire track.
Okay. And so you call it a tire track,
Mm-hmm.
but on this piece of paper, is it reflected?
Yes, that's the beginning of the skid mark.
Okay, so on this piece of paper, you used SM3 to call it a skid mark.
Yeah,
correct?
SM2 and SM3.
Okay, so SM2 starts down here and SM3 up here?
Yes.
And you call it a skid mark, is that
Yes.
correct, on that piece of
Yes.
paper? Okay, but in testifying, you just called it a tire track.
Well, yes, it's a tire track there, and then when it hits, it's part of it. It's the same tire that goes onto the concrete and leaves a rubber mark.
Okay, so then the marking that comes before the driveway, is that a tire track or a skid mark?
On the accident is a skid mark.
Okay, in real life, was it a tire track or a skid mark?
Tire track. Then it begins to
Thank
become a skid mark.
Okay.
I just heard a word. What does that mean?
what's
He
skid-
said accident.
Skid mark means brakes, right? When do you get skid marks? When you slam on the brakes, you get skid marks. That's why she was so adamant. Please, please, please say tire tracks. Confirm tire tracks, not skid marks.
And when she was trying to rehabilitate him and get him to say the word that she wanted, he said yes in the accident. I'm a
She's
juror,
like,
I'm
in
picking
real
up on
life.
that.
In real life. That was
Right.
funny.
Yes.
In real life. This isn't real life.
So that was the bad part of the day for the prosecution.
Yes.
But again, they finished very well. First thing today, the jury went back to the scene, and that's our 13th jury question tonight. Does the jury's visit to the scene help the prosecution or the defense? Now remember, they went there, they drove down the street, they went over the speed bump, they saw the turnaround, all of that today. So in the end, is it better for prosecutors or the defense? Go to CourtTV's Facebook page or my Facebook page. And when we come back, we are going to reveal the results. So you got to vote now. Get your vote in. We'll be right back.
What is the emergency?
I'm at the Circle Food Store and someone just got shot.
The facts of this case can lead reasonable people to different determinations.
One thing you should know about this trial, very similar to the George Zimmerman case.
Marquise McLaughlin was a father. He was shot down in front of his child over a parking spot.
Michael Draka appointing himself as the handicap parking police.
He is a dangerous man.
He shoves you to the ground. I'm on the ground like this. Okay. As I come out like this, he's taking his step. Okay. Was he charging after you? 2 steps running.
What happens if I told you that I looked at the video and in no time or point does he come running up towards you? He actually takes a step back.
I would disagree.
What did Draka see? What did Draka know?
When the jury looks at the video, no one's going to say it was unreasonable for him to have fired.
Draka's history in uttering racial slurs will not be allowed in the courtroom.
All of America is watching Clearwater, Florida.
What does the jury need to find the truth?
He had to shoot to defend himself.
Should never have been prosecuted.
This is not right at all.
Those are the facts, and that's the law.
In his mind, he was defending himself. He could have walked away. Instead, he took a person's life.
Welcome back. You had a preview there of our next big trial down in Florida. It's Florida versus Michael Draka. He's claiming self-defense, and we'll have full live coverage of that. And it begins next week with jury selection on Monday. So get ready for that one. In the meantime, things are winding down in West Virginia. It seems the prosecution is done, although they have not rested yet. Let's take a look back at what happened today in the case of a man who either accidentally ran over and killed John Maynard or did it on purpose.
How'd that happen? Was he joking or is he serious?
Like you can't see anything, see America. That's kind of scary if that's true.
Very scary. Very. How y'all doing?
And this was the powerful bus video from bus number 2 that was shown to the jury today with the bus driver, Jeremy Hicks, who also testified today. I want to talk about him one more time because we took a look at some of the expert testimony from the prosecution. Didn't go so well. This obviously much better for the prosecution. What is the jury thinking about tonight?
The last thing they saw, right? Recency. So thank goodness for the prosecution. The last thing they saw was this very believable school bus driver. I mean, how much better of a witness could you have? You could have a nun, a priest, a school bus driver. I mean, you got the perfect witness who's very believable and very angry. Defense has to pounce on the anger and say...
Is this where the prosecution should just end the case? Because they're pretty sure they're done, but they haven't officially rested yet.
I don't know that they're getting any better than the last witness that they had today. I don't see, unless they've got somebody in their back pocket that's more emotional and more compelling than that second school bus driver. I think today they should quit.
The only other witness we heard talked about that there might be one of the students on the bus who might have been the one that got off there. Would you even go there?
No. What does that help?
Eyewitness?
No, you already have an eyewitness. You have the bus driver.
Well, we have a whole bunch of eyewitnesses.
I mean, I think that was enough. Now, if they could get an eyewitness who was maybe in front by that house, was there someone outside of the house?
Oh yeah, we've got 2 or 3 that have already testified from in front of the house.
Okay, well, that's all. That's it. Don't put anyone else up, because I believe it will dilute their case.
Yeah, because this is the one that saw everything from start to finish.
Well, it's hard to second guess, because really the truth of the matter is we didn't talk to those witnesses. I mean, is this little boy believable? Is the jury going to be mad at the prosecution for putting a little boy in that position again to have to relive what he already went through? So, you know, unless you can really look at it and say, this person's even more powerful than that, which none of us can believe, I think you're right. This is
my guess is that the jury will, in fact, the prosecution will, in fact, rest there. All right, we're going to take a look at the day in review now. Let's take a look at the highlights from In Court today.
There was a male laying in the ditch with a bunch of people around him. As I was pulling up, they were all pointing and hollering that up the roadway that he's up that way, he's up that way. He said he was coming down the road. There was a guy standing at the end of the driveway. He was yelling, waving his hands, screaming, and the male had thrown a beer at his windshield and causing him to lose control of the vehicle.
Was there any indication that the car slid or exhibited some loss of control between that speed bump and the driveway?
Not that I found.
Would you say that this person applied more pressure to the brakes 5 seconds before than 1 second before the event?
Yes, that would be my opinion. But if we assume that the vehicle is continuing to slow for that last second, it would be my opinion that the speed would have been somewhere around 32 to 36 miles per hour.
Would he have had enough time to react and avoid a man standing in the driveway?
If you perceived it at the 324 feet and used a reaction time of 1.6 seconds, at 45 miles an hour, you would have been able to stop. From the speed bump to the driveway, at 45 miles an hour, no, you wouldn't be able to stop.
Oh my God, he just hit that man. He just hit that man that was in the four-wheeler, Terry.
It never hit the brakes, and it never stopped accelerating. From the time it passed me to the time it was asphalt. He never once slowed down.
There's nothing in the police report, nothing in the witness statements, nothing that has come out in witness testimony now about his statements at the scene that has indicated that he lost control, that the speed bump was the problem. He may have even been very familiar with this neighborhood. We heard yesterday from Quade Pendlebury, who said he recognized Vandergriff as the pizza delivery man for the area. So he may have traveled over that road several times and knew exactly where that speed bump was.
All right, the results are in from our 13th juror question. Does the jury's visit to the scene help the prosecution or defense? And 80% of you are saying prosecution tonight, just 20% saying defense. Do you know who asked for the visit to the scene? It was the defense. How about that? All right, so a lot of things happened today, and as we've been discussing, some of it wasn't great for the prosecution. Some of it was extremely powerful, probably their best witness in the entire case. Bus driver number 2, Jeremy Hicks, who was so just the way he testified and what he saw and the way he described it, plus the video, very, very powerful. But in the end, who had a better day? Was it the prosecution or was it the defense? Let me bring back in my think tank. We'll begin with Tiffany Porter, criminal defense attorney. Who had the better day, prosecution or defense? I always start with you. You bet.
Well,
you have to pick one. Don't split it.
Well, that's what I was about to do.
Cannot split it.
Cannot split.
Against the rules.
Well, I would say for right now, the prosecution had the better day.
Why?
Because of the bus driver's testimony. I think that really helped them. It brought the emotion and everything that they needed to really have a human appeal to it versus an expert talking about skid marks and whether he slowed down or not. I think that really helped them. That witness helped them. Now, when the defense gets ready to cross, it may be a different story. But for today, that's what they have to go home. That's what the juror has to think about. And that will be the last thing that they think about as far as his reaction and what happened. That video really shows just the terror. And, you know, it was a frenzy, you know, once he was hit. And so I think that that really helped the prosecution. But we shall see.
We'll see. Randy Kessler, the professor.
Prosecution. It's like you said, you know, the way he said it, what he said, but not only all that, but who he is. He is the hero of the community, you know. Everyone on the jury, they want someone like that to be there. I mean, and look at the video. Not only did he see it, he drove right up to the scene. He said, call the police, call 911, jumped out, went to help. I want to believe everything that guy says. He's the guy that I want on the scene if I'm ever in a wreck or something like that. He was the best witness the prosecution could have had. Good day for the prosecution.
Ashley McMahan.
I'm going to disagree with my esteemed colleagues here, and I'm going to go with defense, and I'll tell you why. Because I think as soon as on cross-examination, I think the prosecution made a mistake by having that expert testify in their case in chief. And I think as soon as you, as the defense attorney, got him to admit that there's a possibility that he could have been braking, and it's coming from an expert, that boom, you have a hole big enough to drive a school bus through in the prosecution's case for the defense. I'm going defense.
All right. I'm going to say prosecution. And the reason I'm saying that is because the way they finished the case and the way he testified, you know, they needed it. It was a little rough going earlier in the day. And I just believe at the end of the day, this jury is going to connect much more with the eyewitnesses and the real people than the experts who are paid from both sides. And the problem with the expert testimony in this case is they couldn't get all the information they needed, and it was very, very difficult to follow. All right, tomorrow's another big day in the courthouse. Let's go to CourtTV crime and justice reporter Julie Janae outside the courthouse with a preview of tomorrow in West Virginia.
Coming up on Friday, the case of West Virginia versus Morgan Vandergriff continues here in Winfield, West Virginia. The jury will return to possibly hear either more from the state or hear the state rest its case. Today, the prosecutor, Jennifer Carr, said she wasn't sure if she wanted to completely rest her case. The judge said she could have a night to think about it and go on the record in the morning. Now, if that happens, then the case will go to the defense, who will present their evidence. We know they plan to take about 2 hours and that they have a handful of witnesses that they plan to call, including the bus depot manager who was originally going to testify for the state. The defense really wants to know what happened to the missing camera footage from the school buses that had multiple cameras and not just one, which is what they received. They also have their star witness, their accident reconstruction expert. He will testify tomorrow, and his information, we know originally his opinion was about premeditation, but the judge said he could not talk about premeditation because he wasn't qualified to do so. But he also included in his report that the defendant was on methamphetamines at the time of this crash. That's something that we have yet to see whether that will come in to testimony, and these jurors will hear it. And we could be in a verdict watch after closing arguments as early as Friday afternoon. That's all here at the Judicial Center in Putnam County, starting at 8:30. Vinny, back to you.
All right, Julie Janae at the courthouse. You heard what she said. We could have closing arguments tomorrow. We could be in a verdict watch. It's Friday. Never underestimate the Friday factor. More verdicts come in on Fridays than any other day of the week, so make sure you're tuning in tomorrow to Court TV. All right, coming up, we're going to switch gears a little bit. the most beloved figure in Philadelphia sports, could soon become a free agent? Where could the Philly fanatic call home next year, all because of a lawsuit? All right, reality TV stars Todd and Julie Chrisley are out of jail tonight on a $100,000 bond. The Chrisleys, there they are, pleaded not guilty to tax evasion and other federal charges. Their attorney told the Associated Press that the charges stem from false allegations made by a former employee. The indictment accuses the Chrisleys of submitting fake bank and financial statements to financial institutions to get loans. So my question for the think tank tonight, so who knows best what happened here? The Chrisleys or the federal government?
You know, I think the Chrisleys are in good shape. They got great lawyers. Steve Freeberg and Bruce Morris are wonderful lawyers, and I actually talked to one of them today. And
what'd he say?
He said, look, the guy that's getting immunity has already admitted forging Todd's name to stuff. He said that this is that the accountant that they were working with was already talking to the IRS. This wasn't like, hey, they're ignoring the IRS, they're thumbing their nose at the IRS. They're already working it out. Look, the bottom line is they got bond. They didn't have to put any money up. Who gets bond where you don't have to put any money up unless they're really not that convinced that they're going to flee because they're guilty? They got good lawyers. I think they're in good shape.
What do you think? TV reality stars seem to be getting in a lot of trouble these days.
I agree that they've got great lawyers, but I'm very intrigued to see what the government has or thinks that they have against them, because it takes a lot for them to ask for. I mean, apparently their office is seeking prison time potentially in this case, and in order for the government to be seeking prison time in a tax evasion case means they at least think that they have a smoking gun. Right.
All right. Now you hear football players on Monday Night Football say it all the time, like Malcolm Jenkins, safety, the Ohio State University. Well, Ohio State wants now to trademark the. They apparently use it on shirts and hats and merchandise that they sell. A rep for the Ohio State University says it's trying to protect the university's brand and trademarks. So the question is, will the Ohio State University be able to take ownership of the most common word in the English language? Tiffany?
Really? No. That is this is the dumbest thing I've ever heard of. That's not going to happen. It's just, I don't even know how to explain it. I mean, that means that we could never use that word ever.
They want to trademark the. And they should do 3 trademarks. They should trademark T, H, and E, right? Or give me a T. Oh, can't. That's trademarked. I mean, I think what they were doing is they were going to trademark the Ohio State University. And they said, well, why start there? Why not start with, you ask for as much as you can get. That'd be a shocker if they got it.
Who came up with that, though? What attorney came up with that?
But you know what? They're talking about it, and we're talking about it.
Well, they got the T-shirts already. It's just a big T-H-E on the shirt and on the hat.
Right. We understand that.
But that's not the way the law works.
Right. They will never get it.
Too much of a common usage. You can't exclude everybody else from saying the or putting the on a shirt or using the word the in any other capacity.
All right. What if you just say the?
No, that's unacceptable.
I own the. I'm not from Jersey. I never say the. I always say the. The.
I thought it was DA. For years,
The guys. Okay. Now, if you're a baseball fan or a sports fan, you probably know the Philly Fanatic. There he is, the big fuzzy green mascot of the Philadelphia Phillies. The Fanatic is in federal court. The Phillies are suing a New York company that actually created the Fanatic years ago, claiming that the creators threatened to terminate the Phillies' rights next year unless the team renegotiated its 1984 agreement to acquire the rights to the mascot. Now, the Phils bought all the copyrights to the artistic sculpture known as the Philly Fanatic for $215,000 back in 1984. But the company who sold them the rights says they can terminate the agreement next June because of Section 203 of the Copyright Act. So my question, will the Philly Fanatic become a free agent after this lawsuit? I've got the lawsuit in my hand. Here it is. Boom.
Well, it's hard to believe, but it's in black and white in the contract that they have the option after 35 years.
It's a negotiation.
The Fanatic's trying to squeeze more money out of the Phillies.
Yeah,
but what else going on here?
Where else is it going to go? Is it going to be the federal
shakedown?
The federal Fanatic or the Pillsbury Fanatic? What's it going to be? The Ferrari Fanatic? I mean,
it's going to be the Harrison Erickson Fanatic.
He's going to Philadelphia. The question is for how much?
Right.
Philadelphia. So you think that the Fanatic stays in Philly and loses this lawsuit?
It's all about the green.
Well, it's all about money.
No, they may
right.
pay him. He
Right.
may be able to demand more money. The
What's
question
he worth?
Well, the question is, it's
$215,000 from 1984.
But it's like an NBA player sitting out. You're going to sit out the season. You're going to sit out the NFL season. He's either going to get what they offer him, or he's going to sit out and the fans are going to boo. But guess what?
Yeah.
He ain't got nowhere else to go.
And depending upon what he gets, right?
Ooh, Harry the Hog.